Good afternoon and welcome to the 2025 White and Case Jessup Cup World Championship match of the Philip C. Jessup International Law Moot Court Competition. I'd like to begin while the judges are out of the room by introducing and congratulating our two teams that are here in the room. To my right and arguing Applicant, National University of Kyiv-Mohyla Academy. To my left and arguing Respondent, Singapore Management University. The judges will be in a moment, but I just want a couple of program notes before we begin. First of all, please take a moment to check your cellular phones, smartphones, tablets, pagers, mobile fax machines, and any other device I might be forgetting. Timekeeping devices that beep, watches, which are apparently not timekeeping devices under the Jessup rules. Thank you. That's been a fight in several jurisdictions this year. Turn them all to silent mode. I'd also ask, remember that the two teams are anonymous to these three judges. I would ask for no signs of national solidarity or any other indication as to any of the teams that might be in this room during the match. And finally, I would ask that there be no disruptions from the crowd. These are two teams at the top of their game who've gotten here by learning from everybody in this room, our judges, their opponents, their coaches, their families, their friends, the teams that all of us, so to speak, left behind at home. And let's do this championship round and the thousands and thousands of people who have contributed to this Jessup year over the last 15 months now, the honor of having one of the greatest championship rounds to date in the Jessup competition. Good luck to you both. They will call all rise in a moment. Thank you.
All rise. The International Court of Justice is now in session. President Donoghue and the honorable judges Gomez, Robledo, and Nolte presiding. The case before the court is the case concerning the Naegea. The parties are Applicant, the Union of Ambrosia versus Respondent, the Republic of Armenia. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Very well, then the session will now begin, and the floor is given to the first speaker of the applicant. Please go ahead. Please proceed.
Madam President, Your Excellencies, may it please this honorable court. My name is Vladislav Levchuk, and I'm honored to appear before you as the agent for the applicant, the Union of Ambrosia, together with my co-agent, Ms. Anastasia Shashkevich, and our agent of counsel, Mr. Vladislav Mikhalchenko. In the next 22 minutes, I will argue that this court has jurisdiction over the submission B, and secondly, that the assertion of criminal jurisdiction, arrest, and prosecution of Ms. Cross in Ravinia are inconsistent with international law. My colleague, Ms. Anastasia Shashkevich, will further assist this court with the remaining submissions C and D in the next 21 minutes. And Your Excellencies, we respectfully reserve 2 minutes for the rebuttal. May it please the court. Starting first, Your Excellencies, with the question of this court's jurisdiction. On May 2nd, 2024, Respondent has prosecuted Ms. Cross by first issuing an arrest warrant based on her alleged complicity in crimes of enforced disappearances. The core matter that the applicant and respondent have brought within the subject matter of the submission B is whether such measures of constraint are lawful under international law. In July 2024, applicant has filed an application before this court invoking Article 21 of the OCDB Charter as the compromissory clause in light of Article 36(1) of this court statute. Your Excellencies, it is our submission that this court has jurisdiction upon the compromissory clause, which has two preconditions, material and temporal one. And it is our submission that both of these preconditions applicant claims satisfies because first, the dispute at hand arose out of facts or situations that happened after Article 21 of the Charter entered into force. And secondly, given that the question of persecution of the former Minister of Ambrosia for international crimes of enforced disappearances is not essentially within respondent's domestic jurisdiction.
Counsel, isn't it necessary for the court to decide this case on the merits, for the court to look at facts and situations that occurred prior to entry into force?
Madam President, could you clarify a question, please?
Is it necessary in order for the court and the respondent state to decide this case, for that court to look at facts and situations that took place prior to entry into force?
Madam President, our answer is no, because the question within the submission B pertains to the question of whether Ravinia has violated law on immunity and jurisdiction. And to adjudicate upon this, the court does not need to delve into the question of natures of the crimes that Ms. Cross allegedly has committed between 2017 and 2020. We would like Your Excellencies to refer you to paragraph 12 of the Statement of Facts, where Article 21 of the OCDB Charter is contained. And the wording of this article says that the member states do not recognize the court's jurisdiction over disputes arising out of facts or situations occurring prior to the entry into force of this article. And according to paragraph 12 of the facts, Article 21 entered into force on March 17, 2021. So, Your Excellencies, for this court to determine whether the ICJ has jurisdiction, the court needs to analyze from which situations or facts the dispute has arose. Respondent may indeed rely on the cases of certain properties where the court has applied the so-called real cause test. Namely, it defined those facts or situations which led for the dispute to emerge. However, we submit that this case is irrelevant for the purpose of this article because the wording of compromissory clause in Article 21 of the OCDB Charter and European Convention for Peaceful Settlement of Disputes are different. In the latter, in the European Convention, which was used as the basis for certain properties, jurisdiction of the court, there was the wording relating to facts or situations. And according to the ordinary meaning that this court should analyze under Article 31(1), the word regarding to has the broader scope. Your Excellency?
I'm not but does your interpretation of the wording not ignore the object and purpose of the real cause component of in the jurisprudence?
Your Excellency, Nolte, we submit that it does not conflict with the object and purpose of the real cause, because if the parties intended to include such wording that the court would have jurisdiction, they would adopt the wording in connection to, relating to, or with regard to, so that the court would have jurisdiction over the broader scope of matters in terms of the temporal. But they decided to adopt the wording arising out. And according to the Black's Law Dictionary, the wording arising out means originating from, having its origin in. And Your Excellencies, as can be seen from paragraph 62 and 63 of the facts, where the president of both states communicated their disagreement on the points of law and facts, the reason why this dispute has emerged and its origin is found exactly in the arrest warrant issued by the respondent and its subsequent enforcement.
But that cannot be the decisive criterion for the interpretation of the jurisdictional clause, because they couldn't think of this particular case. Did the parties want a particularly restricted interpretation or provision establishing jurisdiction by using these only very slightly different words?
Honorable Judge Nolte, unfortunately, the preparatory works of the OCDB Charter do not give us the reference to the reason why they have incorporated such wording. We can see from the paragraph 11 of the Statement of Facts that the reason why the Article 21 was postponed in 5 years was to ensure that the disputes that were in consideration between the parties before 2021 were not brought ultimately for the court's jurisdiction. And exactly this case, Your Excellency, pertains allegedly to the commission of crimes which happened between 2017 and 2020. So we can reasonably infer that it was one of the reasons why such language was adopted. But even if the court upheld that there is no difference in terms of arising out and relating to, as used in certain properties, we still submit that the certain properties case is relevant on the factual circumstances. In the paragraph 48 of the certain properties, the court indeed stated that for the real cause to be established, there has to be an inextricable linkage between the facts and situations and actually the reason why the dispute emerged. However, in that particular case, the real cause and inextricable linkage was to be found in the legislative origin of the confiscation of the painting of Liechtenstein prince. Here, Your Excellencies, we would like to emphasize that there is no legislative origin, and 2007 legislation is not the reason why the dispute emerged, as the respondent contended on the page 4 of their written submissions. Your Excellency,
when exactly the dispute emerged?
Your Excellency, according to paragraph 62, 63 of the facts, it is our submission that is 6 May 2024, when President of the Respondent answered to the disagreement voiced by the President Derry. And Your Excellencies, exactly this dispute emerged after the critical date of entry into force of Article 21, namely in 2024, 3 years after, and therefore the court has temporal jurisdiction to adjudicate on the submission B. Turning then to the question of subject matter jurisdiction, we would like to submit that the persecution of the former Minister of Ambrosia is not essentially within respondent's domestic jurisdiction. And Your Excellency, the major issue here to clarify is the wording of Article 21b2, which can be seen in paragraph 12 of the Statement of Facts. According to this provision, the court does not have jurisdiction over disputes relating to judicial proceedings on matters which, in accordance with international law, are essentially within a member state's domestic jurisdiction. So for this court to determine which matters are essentially or not within domestic jurisdiction, the court should find the answer in international law. And in the Interhandel case on the page 22, Switzerland versus the US, the ICJ established that the court should reach the provisional conclusion that the matter is governed by international law to decide that it does not lie within essential domestic jurisdiction of the state.
Now, the clause with regard to the matter being essentially in the jurisdiction, domestic jurisdiction of a state, is an old formulation. And for years and decades, lawyers agreed that this space shrank because international law expanded so much. Now, these states concluded a treaty in 2016 or later using this clause. I would imagine they wouldn't use a clause which they would know would have essentially no content. So I would assume that for such a clause to make sense, it means it has to be given room. Would it not be possible to argue that criminal cases are typically in a national, done in a national forum, whereas other kinds of cases, international trade or something, that are more obviously international, but to prosecute somebody for criminal prosecution, criminal law is more national. Wouldn't that be an argument?
Honorable Judge Nolte, we agree that generally the law enforcement and domestic persecution are the matters of essentially domestic jurisdiction. And we would agree that the matter would be essential for the respondent if Ms. Cross was, for example, driving a car, being in her private capacity, and was, for example, engaged in the car accident on the territory of the respondent. But the central question here of the judicial proceedings before Ravinian Criminal Court is whether the former Minister of Ambrosia enjoys functional immunity for the acts that were conducted under the governmental ILSA program. And here, there is an invocation of the international element of functional immunity.
I think you may not have understood what I meant by my question. Of course, there's an international legal question with respect to jurisdictional immunity involved. But my question is whether the kind of case that was considered to be essentially under domestic jurisdiction are criminal cases as such. And even if, like in many, many cases, there's some international legal aspect to it, we should not be too complicated, perhaps.
Honorable Judge Nolte, yes, and we understand the reasonableness behind this question, not to make the provisions of the OCDB Charter meaningless. However, the ICJ in the paragraph 25 of its provisional measures order on Tehran hostages case explicitly stated that the detention of internationally protected person, in this respect former Minister Cross, that enjoys functional immunity under custom is the matter which stripes the question of being essentially domestic for the respondent. And therefore, Your Excellency, the court does not have, the court has jurisdiction over the submission B on the subject matter precondition. Turning then to the submission B, Your Excellencies, if you do not have any further questions, we submit that Ravinia violated legal rules on jurisdiction and immunity by prosecuting former Minister Cross. And we have two main arguments in this respect. First, that universal jurisdiction is subsidiary and the respondent first must have extradited Ms. Cross to Ambrosia, given the pending extradition request. And secondly, that the immunity under customary international law prohibits Ravinia to prosecute Ms. Cross domestically. Starting first with the question of universal jurisdiction, Your Excellencies. We agree and we understand that respondent may refer to Article 11, Paragraph 1 of the Convention on Enforced Disappearances in force between parties, as per Paragraph 68 of the Statement of Facts. And indeed, Article 11, Paragraph 1 establishes an obligation to prosecute the crimes of enforced disappearances. However, with one very important caveat, and I would like to quote, if it does not extradite him or her in accordance with its international obligations. Your Excellencies, President Donoghue.
Please explain how you interpret that provision in light of the court's decision in the Belgium versus Senegal case in 2012. Thank you.
President Donoghue, we are aware that in paragraph 95 of Belgium versus Senegal, the ICJ ruled that the obligation to prosecute within the Convention Against Torture is primary and obligation to extradite is discretionary. However, the peculiarity of that particular case was that Belgium has requested the extradition based on the Convention Against Torture. So the court proclaimed that the obligation to prosecute prevails over obligation to extradite within the framework of the single instrument. In this respect, we can see from clarification number 5 that there is a bilateral extradition treaty between applicant and respondent. And according to Article 13, Paragraph 2 of the ICPPD, enforced disappearances should be considered an extraditable offense if the extradition treaty was adopted before convention entered into force. And we have actually requested extradition of Ms. Cross, but according to the last sentence of clarification number 5, respondent has purely ignored and did not respond to this extradition request. Your Excellencies, the common sense approach that the states follow by deciding on extradition is so that universal jurisdiction can be applied as the measure of last resort to combat impunity for international crimes, but still given the room for the states where the crime has been committed due to the accessibility of evidence. And Your Excellencies, here we have requested extradition, and if respondent refused this extradition on the relevant grounds, we would agree that obligation to prosecute should be fulfilled. On the contrary, they ignored our extradition request, And moreover, according to paragraph 61 of the facts, they proceeded with the prosecution of Ms. Cross.
If they would, sorry, go ahead. So if they would have answered, we will not accede to your extradition request because we think you will probably pardon the person, you would have been satisfied.
Honorable Judge Nolte, we are aware of such potential argument from the respondent that they referred to in their memorials. However, first, it is really important to emphasize that for the legitimate grounds to refuse extradition, this has to be the provision envisaged in the treaty. And neither Model UN Extradition Treaty nor any other regional instruments, such as European Convention on Extradition or Inter-American Convention on Extradition, do not prescribe the neither mandatory nor additional grounds as the so-called unwillingness or inability to prosecute. Moreover, the contention of the respondent is also erroneous in terms of fact. Your Excellencies, indeed, in the paragraph 57, we can see that President Derey stated that Ms. Cross, and I quote, was a loyal servant of the people, and that the ILSA program that she governed administered saved so many lives. However, this was said purely in terms of her role as the minister, because according to the statement of facts, Your Excellency, paragraph 10, the drug trafficking and, Your Excellency, illicit fishing as the problem why the OCDP charter, why the OCDP has been grounded. It is really vital for the national security problem for the Union of Ambrosia. And ILSA program was exactly incorporated to combat these issues. And it was a...
Counsel, mindful of your time, Judge Robledo Gomez has a question, and then after you address his question, I'd like to encourage you to move on to the final topic that you wanted to address, please. Please go ahead.
Does your government be willing, or would your government would be willing to give guarantees to the respondent in order not to grant any kind of a pardon or clemency as a way of securing the extradition?
Your Excellency, unfortunately, I cannot answer on behalf of our prosecutor agencies. However, if respondent can request the assurances that there would be no pardoning, we would do so. And it was, for example, in the recent case of Italian Supreme Court in 2024, which have satisfied the extradition request regarding the Ukrainian national, based on the assurances that Ukraine gave that they would not violate the rights of this person during the wartime. What was the main concern of the Italian Supreme Court to grant this extradition? As per request of President Donoghue, we would like to move to our final argument on immunity, where we submit that Ravinia is barred to prosecute Ms. Cross according to the customary rule on functional immunity that is applicable for the acts during the office and in the official capacity. The core question here before this honorable court is whether acts of Ms. Cross are to be regarded as an official capacity. And the respondent may claim that these acts are committed ultra vires, namely in the access of instructions of authority. We recognize that in paragraph 8 of the Statement of Facts, President Derey instructed Ms. Cross to implement ILSA program and to do all lawful measures. However, Your Excellency, the nature of crimes is not at the stake here, because the question of immunity, as recognized in the jurisdictional immunities and arrest warrant, is the procedural matter and not the substantive one. And the court has relied on the ILC draft articles on responsibility of states for international wrongful acts. And as subsidiary means for determination of the rules of law, we invite to consider the draft Article 7, where the ILC stated that even if the acts may be criminal, they are still committed in the color of authority. And Ms. Cross...
Counsel, can I ask you to move to the question of waiver, please?
Certainly, President Donoghue. The potential argument of the respondent is that there is an implicit waiver of immunity under the framework of the Convention on Enforced Disappearances. However, Your Excellency, we submit that ICPPD is silent on the question of immunities. And Your Excellency, on the contrary, for example, Article 4 of the Genocide Convention explicitly waives immunity for individuals in the face of the genocide. We acknowledge that draft Article 10 of the Convention had in its provision the waiver of immunity, saying that, and I quote, any pardon, immunity, or any other exemptions are unlawful under ICPPD. But ultimately, this provision was excluded and is no longer present in the provisions of the ICPPD. And as this honorable court stated in arrest warrant in paragraph 50, even if there is an obligation to prosecute or extradite under the convention, in that respect, the Convention Against Torture, it does not render the customary international law granting functional immunity inapplicable. Your Excellencies, we acknowledge that the goal of the ICPPD is to combat impunity for enforced disappearances. But as per the ICJ in the arrest warrant paragraph 60, immunity does not mean impunity, because the applicant is willing and able to prosecute Ms. Cross, and that is why we have requested her extradition. Your Excellencies, if you do not have any further question in respect of the immunities, we would like to conclude our submission and to ask this court to rule in favor of the applicant, that respondent violated rules on immunity and jurisdiction by prosecuting Ms. Cross domestically. Thank you, and may it please the court.
Thank you. Then the next speaker for the applicant can take the floor. Thank you. Please proceed.
President Donoghue, Your Excellency Nolte, Your Excellency Gomez, may it please the court. My name is Anastasia Shashkevich, and it is a great privilege to appear on behalf of the Union of Ambrosia, the applicant in today's proceedings. I will assist the present court with Ambrosia's remaining submissions C and D. First, pertaining to Rovinia's unlawful issuance of fishing licenses in the parts of the Triton Shoal that are located within Ambrosia's exclusive economic zone. Secondly, Rovinia's unlawful seizure and sale of the Falcon, based on the Transitional Council's waiver of immunity. Turning directly to submission C, Your Excellencies. The applicant brings the case of paramount significance before the present court to rule on the pressing issues of current international law, pending the decision on advisory opinion in respect of obligations of states in light of climate change. Here, Your Excellencies, the applicant raises two arguments: that its fixed baselines are encompassed within Article 5 of UNCLOS as interpreted in line with the rules enshrined in Article 31 of Vienna Convention on the Law of Treaties. Ambrosia in 2015 adopted its freezing law by deciding to fix the location of its low water line as of 1st of November 2015, and later depositing its nautical charts to the UN Secretary General, according to clarification 2 to the statement of facts. As such, Your Excellencies, by disregarding these provisions of the applicant's low water line and normal baseline, Rovinia violates Article 58 of UNCLOS, which requires other states to have due regard to the rights of the coastal state in its exclusive economic zone. Moving to our first argument, Your Excellencies. Interpretation of Article 5 in line with Article 31 of VCLT encompasses both ambulatory and fixed baselines, as long as it is the coastal state that recognizes them. As such, Your Excellencies, we turn to the finding of ITLOS in its advisory opinion in relation of obligations of states in climate change 2024, where in paragraph 130, it recognized that UNCLOS is a living instrument and shall be interpreted considering the developments of law in light of climate change implications. Your Excellency.
Could I ask you, please, I'm familiar with what the ITLOS had to say, but could you locate your argument more precisely within the terms of the Vienna Convention on the Law of Treaties, please?
Certainly, President Donoghue. Here we rely on all elements of Article 31 taken in unity to interpret UNCLOS, specifically Article 5, following from ordinary meaning, the context of the convention in light of object and purpose, as well as increased and subsequent practice of parties to UNCLOS in accepting fixed baselines under the umbrella of UNCLOS. And turning first to the ordinary meaning of Article 5, here would draw this court's attention to the wording, and it is, as I quote, "except where otherwise is provided in the convention, the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast, as marked on large-scale charts recognized by the coastal state." Taking in the context of UNCLOS, where there is no obligation upon the states to update their nautical charts, once the state decides to fix the location along the coast, it shall be then respected by other states accordingly.
Excuse me, you said that, or you suggested that you would rely on the argument that UNCLOS is a living instrument. The argument that you are putting forward now does not presuppose that UNCLOS is a living instrument. Am I correct?
Your Excellency, Nolte, let us clarify. Indeed, it is a living instrument, since the applicant here concedes that at the time of the drafting of the convention, the parties could have only presumed the baseline to be ambulatory because they did not understand the repercussions of sea level rise and climate change and their possible legal consequences upon the practice.
So you're saying it is only now, after seeing sea level rise, that the parties to UNCLOS finally really understand what UNCLOS means?
Not exactly, Your Excellency Nolte. However, sea level rise indeed induced the change in behavior of states in widening the scope of Article 5 to also indicate fixed baselines and not only ambulatory ones. And here we rely on increasing and evolving subsequent practice of parties to UNCLOS. There are three groups of states, first of which explicitly adopts fixed baselines for themselves, such as, for example, small island states, Pacific island states, and Polynesian island states. However, there are also states that retain ambulatory baselines for themselves, while also recognizing the possibility for other states to fix the baselines under UNCLOS, such as, for example...
So if I understand, then I want to understand whether you're proposing a specific interpretation of this treaty for states that are adversely affected by climate change, or are you suggesting that any state is free to use ambulatory baselines when it's convenient? For example, sometimes we have states where the coastline recedes, and there are other situations where, due to deposition, the coastline moves in the other direction. So please help the court to understand your position on that.
President Donoghue, the applicant's position is that the state is its own arbiter of the baseline and indeed may choose to fix it in accordance with UNCLOS. And since the low water line is fixed as a physical feature at the time of depositing the nautical charts, and there is no requirement for subsequent updating of such charts, then they remain permanent and shall be respected by other states.
So, I'm sorry, I don't know that I understand the answer. The baseline is fixed as of the deposit always? What about if the state is disadvantaged by the change that occurs between the time of the deposit and some future date? The state is then required to maintain, or may freely adjust as it wishes? And how does the rest of the world know about that change?
President Donoghue, Your Excellencies, the state may indeed adapt if it uses normal baselines, as in the case of Ambrosia, according to clarification 2. And for other states to be aware of such change, they may refer to the nautical charts submitted in accordance with UNCLOS to the UN Secretary General, which was done by the applicant. Your Excellency, I see.
Yes, Council. Just tell us, would you say that climate change and consequence of it being sea level rise has created a fundamental change of circumstance situation? And if so, how would you argue, would you invoke the fundamental change of circumstances in support of your argument, in support of your position? Help us understanding better.
Your Excellency.
And further to that point, would the state of Ambrosia consider itself as a specially affected state?
Your Excellency Gomez, answering your first question, the applicant does not invoke fundamental change of circumstances under Article 62 of Vienna Convention on the Law of Treaties as a ground for termination of a treaty. Here we only deal with unilateral act of determining the normal baseline, and therefore it is inapplicable to the present case. As to whether the applicant considers itself to be special affected state, the answer is yes. However, it would be for the purpose of the formation of customary international law, which is the alternative argument of the applicant in respect of the regional practice that has shifted since 2016. Your Excellencies, turning then to a subsequent practice, which is in favor of encompassing fixed baselines under Article 5 of UNCLOS, there is tacit acceptance as underlined in LSC draft conclusions on subsequent agreement and subsequent practice that can be the ground for the agreement among the parties to the convention to indeed progress and read into the wider scope of Article 5.
I understand that you are making the argument that there are a number of states which engage in a practice in your sense, and the rest of the states parties to UNCLOS are silent. Is that the point you are making? And if so, is it really true that all the other states are silent?
Your Excellency Nolte, there is no state except for Romania that would explicitly object to fixed baselines. However, there are indeed parties to UNCLOS which have not yet voiced their opinion. But in the submissions to ILC in respect of their report on sea level rise in relation to international law, a number of states that consider their interests to be affected by these repercussions voiced their opinion in their written statements.
Well, if I'm not mistaken, there are states, maybe 2 or 3, who have stated that they reserve their position and that this is a difficult question and one shouldn't jump to conclusions. How would you evaluate this practice? Is that positive practice? Is that negative practice? Is that something in between? And if it is something in between, how should we assess it?
Your Excellency Nolte, indeed, it is the applicant's position that silence can amount to positive practice in establishment of the agreement between the parties. And since some of the states do not consider probably their legal interests to be affected by including fixed baselines under Article 5, then it is presumed that it now is widened in scope and encompasses such a possibility for the state to proceed.
Counsel, are you taking, is your state taking the position that the information available to the court regarding subsequent practice establishes the agreement of the parties to the Law of the Sea Convention regarding the interpretation that you're putting forward? That's your position?
President Donoghue, in this respect, we admit that the court's interpretation in the present judgment could affect other parties to UNCLOS, and under Article 63, Clause 2 of ICJ statute, the register will notify other parties in respect of the construction of the treaty if they wish to put forward their position in this respect.
Sorry if I wasn't clear. I wasn't going to this procedural point, but rather I'm just trying to understand that you take the position based on statements of states, silence of states, and statements by states that they are reserving their position. All of that taken together leads you to conclude that there is agreement of the parties to the Law of the Sea Convention that's consistent with your interpretation. Is that your position?
Yes, President Donoghue, it is.
So in your view, silence is the same as a state reserving its position then?
It can be acquiescence to the practice accepted among other parties in which they either actively engage or do not oppose to it. Your Excellencies, as such, Romania lawfully exercised, Your Excellency, pardon me, Ambrosia's rights were violated by Romania by issuing licenses in the parts of the Triton Shoal that lie in exclusive economic zone of the applicant state. Turning then to submission D, Your Excellencies, where Ambrosia puts forward the violation by the respondent of customary international law on immunity of state property. Here, the crux of the matter is whether the Union of Ambrosia agreed to enforcement measures against its sovereign asset, the Falcon. And the answer is in the negative, since at the time only Ms. Zavala, which was the acting president of Ambrosia, could issue a valid waiver of immunity. However, she did not do so in accordance with paragraph 45 to the Statement of Facts, where she transmitted to the Primordial National Court her statement on the fact that the Falcon still enjoyed immunity. In this respect, Your Excellencies, the applicant relies on two arguments, which are alternative in their nature. First is that the customary international law as of today grants governmental status to the entity which enjoys constitutionality, even if lacking effective control. Secondly, if the court agrees with the position of the respondent on the application of effective control legal test, then the Transitional Council still did not satisfy two criteria, namely ascertance of permanence and acquiescence of population. Proceeding with the first argument of the applicant on constitutionality. Here, Ambrosia indeed acknowledges that for a long time, effective control over the territory was determinative of the status of an entity under international law as the government.
Excuse me. I wonder about this position of effective control. Don't all parties in Ambrosia agree that the constitutional president of Ambrosia is still the constitutional president, and that the constitution continues to govern the situation? Isn't the situation just a sort of a possible simple illegality and not a question of constitutionality?
Your Excellency Nolte, indeed it is undisputable that only Ms. Zavala remained constitutional representative of the state. However, in this respect, the applicant puts forward before this court various violation in respect of customary law on immunity of state property, because by relying on its recognition of the Transitional Council as the government of Ambrosia, it led to the acceptance of an invalid waiver of the Falcon's immunity that the Transitional Council could not issue. And Your Excellencies, here we may proceed with our argument on the Transitional Council indeed lacking the effective control, if you wish, or proceed with constitutionality argument. Your Excellencies, turning then to the effective control argument on the Transitional Council not meeting the requirement of ascertance of permanence and acquiescence of population. The respondent here relied on, in its memorial, on the test put forward in Tinoco arbitration, where William Taft elaborated upon 4 criteria for governmental status under international law. They are the effective control over the territory, acquiescence of population, reason...
Counsel, sorry to interrupt your review of those criteria, but could you speak more specifically about, in this case, the timing? So, at what point in the life of the Transitional Council was the waiver made?
Your Excellencies, President Donoghue, indeed the Transitional Council issued the waiver only 4 days into its establishment, namely on 17th of March 2023. Well, it was established on 13 March of 2023.
And is that relevant to your argument?
It could be relevant, President Donoghue, as it shows that the Transitional Council at the time could not ascertain its overall control over the territory of Ambrosia. However, we admit that the respondent indeed accepted the waiver when waiting for the Transitional Council to reestablish itself in the territory of the state. However, it does not render the applicant's argument futile in respect of lack of permanence for 3 reasons. Your Excellencies, the Transitional Council itself named itself as an interim government for Ambrosia, waiting for the awakening of President Ray. Secondly, it operated only for 9 months, issuing its waiver 4 days into establishment, as well as dissolved itself upon the return of the President Ray to Ambrosia in paragraph 56 of the Statement of Facts. As to the acquiescence of population, the Transitional Council could also not enjoy from the habitual obedience of the bulk of population, as evident in paragraphs 47 and 48 to the Statement of Facts, where it is precisely mentioned that opposition has emerged among legal scholars as well as activists that came to protest and were violently suppressed by the police, which was under the Transitional Council.
Do you find any relevant jurisprudence of this court, of the International Court of Justice, that you can point us to in support of your case?
President Donoghue, in respect of ICJ's, unfortunately, no. However, we may refer to national cases, for example, in Fiji versus Prasad, where the Constitutional Court of Fiji underlined that the passive compliance could not be qualified as the acquiescence of people, considering that white protests were suppressed by the entity and ensured and led to violent clashes. And the entity operated only for 7 months in that specific case. And here we also deal with this interim and provisional entity that could not act on behalf of the state in its dealings. Your Excellencies, as such, the Transitional Council could not meet the support of the population of Ambrosia, as well as to assert a reasonable prospect of permanence. Your Excellency.
Now, if I understand the statement of facts, the agreed facts correctly, Ambrosia was very quickly in a situation where there were only isolated and certain individual acts of protest or resistance. But that is normal. That exists in many states and also in such transitional situations. So what is the purpose of the effective control test if you can dispose of it by pointing to a few people who don't agree?
Your Excellency, note that to compare, for example, in situation in Bangladesh in 2024, no protests have emerged against the entity that came into power. However, here we have violent clashes with police that indicate that there was a widespread repudiation of the Transitional Council from the supporters of Ms. Zavala that still retained her claim to presidency and aimed to regain control of Ambrosia, as can be evident from paragraph 40 to the statement of facts. And as long as she remained the acting president of Ambrosia, only she could act on behalf of the state in deciding the fate of the Falcon.
What account should we give to the statement by President Derry, which he gave on 24 of May 2024, where he called the seizure and sale of our aircraft illegal?
President Donoghue, indeed, it only indicates that President Derry did not adopt or acknowledge the Transitional Council's dealings in international fora, but contested that they could not act on behalf of the Union of Ambrosia in this matter. Your Excellencies, if you have no further questions, this concludes the applicant's submissions. Thank you. May it please the court.
Thank you. When the respondent's first speaker is ready, then the respondent's first speaker may take the floor then. Please proceed.
Madam President, Your Excellencies, may it please the court. My name is Erica Wee, and together with my co-agent, Ms. Genevieve Wu, and our off-counsel, Ms. Levin Swee, we appear on behalf of the respondent, the Republic of Rovinia. I will speak for 21 minutes on the first two prayers, while my co-agent will speak for 22 minutes on the final two prayers, and we respectfully reserve 2 minutes for our rebuttals. Your Excellencies, I make two submissions. The first is that this court lacks the jurisdiction to hear the claim concerning Minister Cross, as it falls outside both the temporal and material scope of the compromissory clause under which present proceedings have been commenced. And second, even if this court has the requisite jurisdiction to hear the claim, this court should nevertheless find that the respondent did not violate the international legal rules on jurisdiction or immunities by arresting and prosecuting Minister Cross. And so I begin first with my submissions concerning the jurisdiction of this court. Agent for the applicant has rightly outlined that this court's jurisdiction is founded on Article 21 of the Charter for the Organization for Cooperation and Development in the Pain, under which what parties had effectively agreed would be to accept this court's compulsory jurisdiction, barring two carefully negotiated exceptions. The first, a temporal exception, and the second, a subject matter exception. And while the respondent intends to rely on both, it first bears mentioning that we need only succeed on one for this court to be with me that it does not have the requisite jurisdiction to hear the claim. And so I turn first to this court's temporal jurisdiction. Now, on this point, Judge Gomez Robledo had queried agent for the applicant as to when exactly did the dispute between the parties arise. Agent for the applicant proffered the date the 6th of May, 2024, and we agree, we don't intend to contest that particular fact. But the question the agent for the applicant must answer is whether ultimately the dispute arises out of facts or situations that occurred prior to the entry into force of the clause, not the dispute itself. And this is a function of the language of the compromissory clause and the function that these temporal restrictions were meant to serve. These clauses are what are known as double exclusion clauses, as has been acknowledged by members of this court, including Judge Shi in his dissenting opinion to the 2004 legality of the use of force case, as well as President Iwasawa in his separate opinion to the 2024 decision on the application of the third at paragraph 3. In this regard, Madam President queried agent for the applicant, therefore, as to whether it is necessary for this court to adjudicate upon facts that occurred prior to the entry into force of the clause. And not only do we say, yes, this court must, but that is precisely the relevant test that this court must undertake in determining whether or not its temporal jurisdiction has been excluded. This is in line with this court's 2005 decision of certain property and its 2012 decision of jurisdictional immunities. Now, at this stage, I note that agent for the applicant had argued that this court's 2005 decision of certain property does not apply because the phrase relating to and arising out of are different in those two compromissory clauses. But not only was this difference negated by Judge Owada in his dissenting opinion to certain property, where he in fact assessed the travaux préparatoires to the European Convention on the Peaceful Settlement of Disputes, and found that it originally contained the phrase arising out of, and subsequently changed it to relating to, finding that there is in fact no distinction between their definitions. But if we were to take the applicant's case, that arising out of is different, then in fact, this court in its 1998 decision of fisheries jurisdiction found that the phrase arising out of takes, or quote, is language which brings out more clearly the broad and comprehensive character of the exclusion. And so the difference between the phrase relating to and arising out of does not defeat our case, it assists it. But on the application of then what are the facts that this court, Judge Nolte, did you have a question?
Well, I'm constantly asking myself, you are speaking about the difference between arising out of and relating to, but the provision speaks of disputes arising out and disputes relating to. And at the beginning, you conceded that the dispute arose later and it is within the jurisdiction. So I don't quite follow.
We accept that the dispute itself crystallized in 2024, but that does not detract from the assessment that this court must take in determining whether it has temporal
Okay,
jurisdiction.
you make a difference between crystallizing and arising out.
Yes.
Okay, thank you.
The test here that this court has consistently applied is whether it has to adjudicate upon facts before the entry into force of the clause. And the relevant facts that this court must consider in determining whether or not Minister Cross was entitled to functional immunity under international law would include matters such as, for instance, were these crimes of enforced disappearance crimes against humanity as defined under Article 5 of the International Convention? That requires this court to assess whether those acts were committed in a manner that was widespread or systematic. Likewise, when this court considers whether the enforced disappearances here constitute a jus cogens violation, such that, again, an exception would apply, this court again would have to assess the nature of those enforced disappearances to determine whether or not that exception has been engaged on our present facts. Those crimes occurred between 2017 to 2020, well before the entry into force of the compromissory clause in 2021.
Counsel, if you consider that the acts ceased well before the critical date, what would be the position of Romania if we consider that these acts involve acts of enforced disappearance, which, according to the convention itself and to world-known jurisprudence, are continuous acts. And those continuous acts may well deploy their effects well beyond the critical date. Then what would be your position? Would that trigger or not jurisdiction?
This court's temporal jurisdiction would still be excluded. And I note that Judge Robledo's question goes to, for instance, the jurisprudence of the African Court of Human and People's Rights, where it's been determined that enforced disappearance is a continuing act to the extent that it has not been acknowledged by the state. And this also engages questions of perhaps Article 14 of the Articles on State Responsibility. But here, our submission is that even if those enforced disappearances are of a continuing nature, that does not detract from the question before this court, which is whether, yes, Madam
Could you
President.
turn to the question that was posed to your opponent and speak a bit about how you believe the court should understand the exception that's in subparagraph 2, small 2 of B, please? So we need to hear your view on the wording of that clause and what it means, please.
Of course, Madam President, and again, the respondent can rely on either of these exceptions. On the subject matter exception, the key phrase for this court to interpret is disputes relating to judicial proceedings on matters essentially within a member state's domestic jurisdiction. The key question here is whether the enforcement of domestic criminal legislation is essentially within a state's domestic jurisdiction, and we submit that it is. Here, the question, or what this court must consider, is the fact that these domestic Rovinian proceedings were ultimately taken pursuant to the Rovinian Criminal Code, not its obligations under international law. And there's a distinction between the word essentially that we find in this compromissory clause as against words like solely or exclusively that have been considered, for instance, in Article 15, paragraph 8 of the Covenant on the League of Nations, or in this court's predecessor's 1923 decision of nationality decrees. We submit that if this court wants to look to whether domestic prosecutions are indeed within a state's domestic jurisdiction, then this court need only look to what the applicants themselves had proposed in the negotiations in the formation of the OCDP Charter. What Your Excellencies will see is that at paragraph 11 of the Statement of Agreed Facts, the applicant in fact proposed that domestic prosecutions of crimes like illegal fishing or drug trafficking would be excluded from this court's jurisdiction. But those are transnational crimes which we accept have some international or do engage some international obligations under international law, but to the extent that the applicants themselves accepted that this would not fall outside what is essentially within domestic jurisdiction, then this court must take the same approach to viewing here the domestic prosecution of enforced disappearances. This approach to looking to parties' negotiations has been taken by this court, for instance, in its 1996 decision of oil platforms at paragraph 29. And so I move now to address this court on the merits of the dispute. Specifically, we submit that the respondent did not violate the international legal rules on jurisdiction or immunities by arresting and prosecuting Minister Cross. On the first question of universal jurisdiction, we move to address the fundamental question of whether the respondent, in light of a bilateral extradition treaty between the parties, was entitled, nevertheless, not to extradite Minister Cross, but to prosecute her in line with our obligations under Article 9, Paragraph 2, and Article 11, Paragraph 1 of the International Convention on Enforced Disappearances. Now, in this regard, we submit that the respondent could rely on a customary exception to the obligation to extradite, specifically where the requesting state has proven itself unwilling or unable to prosecute the matter. This is in line with the UN Secretary General's 2024 report on the scope and application of universal jurisdiction, where it was noted that this is the position taken by numerous states across jurisdictions. And so it is our position that the respondent was indeed entitled to rely on this customary exception, and I turn to address the facts that support that conclusion. Here, Judge Robledo again queried agent for the applicant specifically on whether the applicant is willing to or has undertaken any guarantees that it would prosecute Minister Cross. And it is clear on our facts that not only have they not, but they are not willing at the time to do so. Here, the question before this court is whether, in light of all the evidence already before the Ambrosian Prosecutor General, as well as the actions of President Duray, whether the respondent state could presume that the applicant was indeed unwilling to prosecute the matter.
So, Counsel, could I stop you for a minute? I think maybe I don't follow your argument. Are you saying that in order for the court to find in your favor on this point, we have to find a customary provision that applies here? I'm confused because you started your argument by referring to two particular treaties, so we would have thought we'd be directed towards the interpretation of the treaties, in particular the treaty involving enforced disappearance.
To clarify, Madam President, here we accept that those are the two relevant treaties. However, here Article 9 and Article 11 of the International Convention provide that the respondent does indeed have an obligation to prosecute, but this is if or unless it chooses to extradite such alleged offenders under any other international obligations. This is where we accept that the bilateral extradition treaty that stands between the parties is indeed a relevant consideration. This was also noted by Special Rapporteur Kyiv-Mohyla in his 2018 treatise on the obligation to prosecute or extradite. But in answering whether the respondent, despite having that obligation to extradite under the bilateral extradition treaty, could nevertheless not extradite her, this court must turn to consider whether a customary exception exists for that obligation. And that is a submission we make before this court. In light of the facts, what this court must consider is that not only did the Ambrosian Prosecutor General close investigations early, despite having access to some of the evidence directly incriminating Minister Cross, but the evidence required to make, for instance, file an arrest warrant or file a charge against her are already present in the applicant state. There is documentary evidence of the fact that she was indeed at the detention compound. There is evidence that there is eyewitness testimony, audio recordings, signed visitor logs that show that she was indeed directly involved in these enforced disappearances. And this much is clear from paragraph.
Council, if we're looking at how to fit together the provisions of two treaties, one multilateral, one bilateral, aren't we still then in the world of treaty law? Don't we need to address this issue in part through the lens of treaty law?
We can, Madam President, and here we would be looking to how we can harmoniously read these two treaties and these obligations between the parties. And that is why when we read the phrase, unless it extradites or if it extradites, in accordance with its international obligations in the International Convention on Enforced Disappearances, we look to how the bilateral extradition treaty is that international obligation. And we accept that this is a fact that distinguishes the present case from this court's 2012 decision on the obligation to prosecute or extradite, where there was not a bilateral extradition treaty between the parties. But even if we look just to how this court interpreted those provisions that are in fact in pari materia provisions to that under the International Convention on Enforced Disappearances, then this court will find that at paragraphs 92 to 97 of its decision, it found that states like the respondent state are under an obligation to prosecute with merely an option to extradite. And so if this court is so minded to look to the obligations of parties under the treaty, then those obligations show that the respondent did indeed act in compliance with international law by choosing to prosecute Minister Cross as opposed to extradite her. Now, I move to now address this court on the question of Minister Cross's functional immunity. In this regard, agent for the applicant has focused this court's attention on whether there exists an ultra vires exception for the application of functional immunity. But as Madam President noted, we would like to focus our submissions on whether, in ratifying the International Convention on Enforced Disappearances, to which its object and purpose is to prevent impunity, and under which it defines the crime of enforced disappearance as one committed by state officials with the support and acquiescence of the state, and because it confers upon foreign states like the respondent extraterritorial universal jurisdiction, can it necessarily be said that functional immunity must logically still apply? Because in so doing, what this would do would be to confer upon states a right to exercise such jurisdiction, but yet prohibit states from doing so.
Counsel, let's assume we do not accept your argument. Do you have an alternative argument?
We do, Your Excellency. We can rely on a customary exception under international law for functional immunity, and this was most recently noted in 2025 by the ILC Special Rapporteur report on state official immunity, where in draft Article 7, it acknowledged that there does indeed exist a customary exception for the application of functional immunity where the crime of enforced disappearance has been.
Did the ILC say that, or did the special rapporteur say there is a customary exception? Really?
To clarify, this was codified in draft Article 7 of that report.
Does it say customary exception?
It refers to state practice and opinio juris in support of a customary exception. And this is cited at paragraphs 25 to 26 of that report, specifically.
Well, the International Law Commission does not only identify customary international law, it is also, and that is its original purpose, a proposed text to be adopted by states. And perhaps what the ILC is doing in this context is to develop a text which would they submit to states. So maybe, what kind of text is that you're talking about?
We rely not so much on the enforceability of the draft articles. We know they are merely draft articles. What we rely upon is the fact that numerous states have supported these draft articles as evidence of state practice. Madam President, I know my time.
Please go ahead and finish the answer to the question, and then your time will be up.
Thank you, Madam President. We rely on the state practice and opinio juris that was surveyed by the Special Rapporteur, in which multiple states across multiple jurisdictions and multiple domestic courts have found that state officials can indeed be tried for the crime of enforced disappearance. Unless there's anything further,
Thank you.
thank you. May it please the court.
The second speaker on behalf of the respondent is welcome to take the floor. Please proceed.
Thank you. Madam President, Your Excellencies, may it please the court. As earlier introduced, my name is Genevieve Wu, and I too act on behalf of the respondent, the Republic of Romania. I will continue the case for Romania on the third and fourth prayers. Beginning with the third prayer, the contention is about where the applicant's exclusive economic zone, or EEZ, is. And this turns on the question, as put by the International Law Association in their 2012 Sophia report, whether the baseline is a line on the chart or a line on the ground. In other words, whether the baseline follows what is illustrated on the chart, officially recognized by the coastal state, or it follows physical reality. Now, the applicant has submitted that it is the former for the specific context of states preserving their zones in light of climate change. And they do so on three bases. First, that this is supported by the object and purpose of the convention. Second, by an evaluative interpretation of the convention. And finally, by subsequent practice informing the treaty interpretation. And I will disprove each of these elements in turn. Starting first with the object and purpose of the UNCLAUSE, it is clear that the convention was meant to create a stable regime for the law of the seas, but stability that is reached by a compromise struck by states parties to allocate their maritime rights to the extent that their land territory and their coast extends. In other words, the land dominates.
Counsel, sorry, if I could just back you up a little. So you've indicated that you're going to start your argument with the object and purpose, but could you start instead with the text of Article 5 and help us to understand how you interpret that in light of the other considerations that are relevant, please?
The text of Article 5 shows that the chart recognized by the coastal state plays an important role. But what it does not say is whether the chart determines the baseline or serves some other function, like evidencing where the chart is. So the text is ambiguous in itself. And that is why this court, to understand the text, has to refer to other elements of treaty interpretation in Article 31 of the VCLT, including the object and purpose. The object and purpose closely relates to the fundamental principle that the land dominates the sea. In other words, it is the coast that is the source of the maritime rights of the state, and this principle has been repeatedly recognized in these courts.
I would like to ask you a hypothetical question. Let's assume there would be a volcano eruption on the coast of a state that has submitted a chart. And this volcano eruption would result in 400 meters of additional territory to that state. Where is the baseline? The chart or the new territory?
The baseline would follow the new deposed territory that has been added. And I know this also pertains to a question raised by Madam President about situations where rather than land receding, land might be added to the territory of the state. And we submit that the position to be taken that is principled and consistent is for, in either situation, for the baseline to follow the physical reality. So if the land moves in, the baseline moves in. If the land moves out, the baseline moves out. This was also recognized as a consistent position by the ILA in their Sophia report. And this is also consistent with this court's jurisprudence, where it has looked behind the charts deposited by the state to determine the geographically accurate coastline of the state, as for example, it has done in its 2007 Caribbean Sea decision between Nicaragua and Honduras, as well as the 2001 Maritime delimitation case between Qatar and Bahrain. And because this is a long-standing position of the UNCLOS, what the applicant is suggesting that there is a permissibility for the fixing of baselines, and such a deviation from that long-standing practice will go against the object of preserving stability and certainty, where states knew for so long that all they had to do was to look to the physical reality.
Counsel, how would you reconcile your position with the principle of permanent sovereignty over natural resources, which is inherent to the right of self-determination, which has been recognized as a peremptory norm of international law? So the stability of maritime areas, which allows the applicant to continue exploiting the resources that are in its exclusive economic zone, is consistent with that principle of permanent sovereignty over natural resources. How would you reconcile that with your position?
It would be consistent insofar as the entitlement of the applicant to natural resources within 200 nautical miles of its coastline has not changed. It is entitled to that same amount. But that is quite different from saying that the applicant can continue to assert entitlement on an EEZ that no longer belongs to it, but belongs to the high seas for every other state to fish on the natural resources. And this is quite similar to how the idea of historic rights is something that is not codified in the UNCLOS, and as made clear by the Permanent Court of Arbitration in their 2016 South China Sea case, that principle of historic rights is overridden by the allocation of rights based on zonal systems like the EEZ in the UNCLOS.
Counsel, if we go back to Judge Nolte's hypothetical, think about that. A new peninsula is created. That's one scenario. Another scenario more relevant to this case, the land mass shrinks. The state prepares new charts and submits the new charts to the United Nations that correctly, let's just assume correctly, indicates the low water line. Shouldn't those charts be given relevance? They're accurate, they're reliable, hypothetically available, informative to the world. Why isn't that the way forward?
I'll address those several points in turn, Madam President. First, to get to the relevance of the chart, we do not submit that a chart is completely irrelevant. They are important as presumptively accurate evidence of where the chart lies, or where the coastline lies, my apologies. But that is quite separate from saying that the chart is the be-all and end-all of where the baseline is. That is made clear by the Travaux Préparatoires, where when drafters stated that when it is proven by evidence that the chart is inaccurate, then it is subject to challenge by another state before a court or tribunal, as mentioned in, for example, the 1954 and 1952 fourth session of the ILC at pages 171 to pages 178. And as for, Madam President, your second point about, Madam President, could you please remind me about the other relevance of the chart that you mentioned?
I was just asking you generally what the relationship is between the part of Article 5 that speaks to the low water line and the part that speaks to the charts. I think you may have answered my question already, so I think you can go ahead.
Thank you, Madam President. And On this note, I would like to address a point made by the applicant, again, that states can simply choose whether their baselines are fixed or ambulatory. And Madam President had asked, how do states know the position of other states? Indeed, they do not know first whether other states' land had receded or expanded. They have to check it. And not only that, they do not know what the position of these other states are in relation to fixed or ambulatory. This means that a state will have to constantly check with every single other state what their legal position is, and that undermines the object and purpose of legal stability and certainty under the Convention.
Could I take you back to my questions about treaty interpretation, if I may? So there are varying arguments one could make about what we know about the positions of various states, but let's just assume that we're a few years ahead, and let's just say that, say, 140 states have indicated, have either asserted a mobile baseline or have taken the position that such baselines are consistent with the Law of the Sea Convention. So then how, under the Vienna Convention on the Law of Treaties, how does your state take stock of that growing agreement, apparently, of the parties to the treaty on a particular interpretation of the treaty?
That turns on the question of whether there is sufficient subsequent practice that establishes an agreement of states parties about the interpretation of the term under Article 31(3)(b) of the VCLT.
But the ILC has also said that partial subsequent practice under Article 32 may play a role.
So if you could address both of those, please.
I'm supplementing the President's question.
And that is true, Your Excellency, although the ILC did say in its 2018 draft conclusions that practice between a limited number of states can be considered under Article 32, although that carries less weight than that under Article 31(3)(b). And I note that the threshold of practice under 31(3)(b) requires all states parties to have either engaged in a practice, or if they did not engage in a practice, to have accepted the practice of other states. And I note that this is something mentioned in the 2018 ILC Special Rapporteur 5th report, which I know Your Excellency was Special Rapporteur of. And
it seems that you're not the only person in the room who's aware of that. Let me take you back to Article 31.
Yes.
Let's assume that we don't have any, let's leave aside the supposed persistent objector argument. Let's just assume that that's not of interest to this court. And we have a large number of states in the 140 range, and others have said nothing, or, as was suggested earlier, reserved their position. At what point are the conditions in Article 31 regarding subsequent practice, at what point are those met?
If it's the situation that 140 out of 170 states parties to the UNCLOS have taken that position, then we can accept that, assuming that the remaining 30 have accepted the views of the 140, then a new understanding has been accorded to allow states to fix their baselines. But that is not quite the situation, actually, based on the submissions of states parties to the ILC. And I note that Judge Nolte had asked agent for the applicant whether there were 2 or 3 states who mentioned that this is merely something that is an emerging norm or something that is unclear. Now, there's not just 2 or 3 states. In fact, there are at least 24 states who have expressed views to this effect. And just to name a few, this includes Thailand, the United Kingdom, Cuba, Tonga, Malaysia, states in Europe like Romania, Poland, South America, Argentina, Chile.
Sorry, what was the first state you mentioned?
If I can name one state submission, for example, that of Iceland, it stated in their submission to the UNGA in 2021, and I quote, that it was too early to comment on the precise legal implications of sea level rise for the convention, end quote. And later in 2023, it stated on behalf of the Nordic states that there is an important difference between saying that there is no obligation to update the charts under the UNCLOS and equating that to saying that baselines are fixed according to the charts. This view...
Does this mean, if I accept that situation, but would the court not, if it would accept your position now, arrest a development of international law, which a large majority of states seem to be pointing to, and a small minority not really objecting to?
Well, that is an important concern if the position was that baselines were always fixed and there's a small troublesome minority that is opposing that position. But the reality here is that the long-standing position is that baselines are fixed. And what the applicants are seeking to do is to change that long-standing legal status quo in favor of a fixed baselines approach. Therefore, it is not just a question of a few states who are opposing, but quite a sufficient number, at least 24, as I've mentioned, that have expressed a view similar to that of Iceland, which I've cited. And to address the final points on the evolutive interpretation, I note that Judge Robledo had asked whether there is a fundamental change of circumstances here. And as the agent for the applicant has rightly pointed out, there is no fundamental change that it seeks to invoke here. The question remains whether it can rely on the change of circumstances to dynamically interpret Article 5 of the UNCLOS. But this court has set out requirements for applying that doctrine in its 2009 navigational and related rights case, including that the term interpreted must be generic. But here, Article 5 is not a generic term. In fact, it is a carefully constructed provision when seen in light of its neighboring provisions like Article 7(2), which provides for straight baselines method of drawing the baseline. That provision is important because it specifically provides for the chart recognized by the state to remain permanent, irrespective of subsequent regressions of the coast. And the presence of such an exception in Article 7(2) means that drafters had contemplated the possibility of fixed baselines, but excluded it for the purposes of Article 5. And an evolutionary interpretation would cut against that intention of states parties. Turning then to address the final issue concerning the seizure and sale of the Falcon. We agree with the applicant that the central question is who was the government of the applicant at the time. Where we disagree is on the applicable test. The applicant has submitted that the only requirement is constitutional legitimacy and not effective control. But we submit to the contrary, that effective control is the only requirement. But to first understand what is the correct test for determining the government of a state, we must begin with the purpose of such a test. And the purpose is to identify who is capable of causing a state to comply with or violate international law. And that...
Excuse me if I may interrupt. So what you're saying is governments in exile are irrelevant?
They are not, Your Excellency, they are not irrelevant insofar as we are concerned with the conferral of official recognition, which carries with it political and normative dimensions, as has been done, for example, by the UN's Credential Committee. But what we are concerned here with is not official...
Sorry, Counsel, are you saying that official recognition carries normative value? Did I understand correctly?
It does?
No. Well, then tell me, do you know about any rule of international law, either universal or regional, that gives, that obliges a given state to seek and get and obtain recognition for that state or that government? It can apply both to state and government. Is there a rule that obliges that state or government to seek and obtain recognition for that state or government to be considered as a legitimate one?
We submit that there is in fact no obligation, whether internationally or regionally, for states or governments to seek that kind of recognition, although we accept that there are elements of statehood that are well established under the 1933 Montevideo Convention, which are not in question before this court. But as for the recognition of governments,
Slovenia and Ambrosia are part of a group of states which have signed the OCDP Charter, the first article of which says that they intend to protect the rule of law and our democratic institutions. Now, even if the court would say, okay, under universal law, effective control is determinative, would we not have to say these 7 states are a democratic community and they cannot just accept the exercise of raw power and follow the exercise of raw power?
well, Your Excellencies, I can see why Article 1A of the Charter prima facie seems to cut against the recognition of the Council. But if I were to invite this court to consider the ambiguity about the meaning of the rule of law here, and the question raised by Judge Nolte earlier about whether the fact of the matter is that the constitutional precedentary of the applicant state has not changed. It has not changed before the Council was established, and it has not changed during the Council's administration. In fact, the Council made it clear that once President Derry was able to assume office, it would dissolve immediately, and it did so, as promised at paragraph 55 of the facts. The other reason why I say the OCDP Charter supports the recognition of the Council by the respondent is the second part of Article 1A as well as Article 1E. Article 1A in its second part points to democracy, which does not expressly stipulate for example, democratic processes and elections, but points to the substantial need for substantial democracy. And we would characterize that as giving effect to the will of the people or the right to self-determination, which is a right enshrined in the ICCPR, which both states are parties to. There are compelling...
You are aware that the argument of real and substantial democracy has been used and abused, and that there is a certain danger with that argument.
There are certain dangers with that argument. I note my time, Madam President.
Please go ahead and finish the answer to that question, and then your time will be up. Thank you.
Thank you. The reason why it was not used in an abusive interpretation here was because there were compelling reasons for the Council to have assumed power. Now, not only do we see that the Zavalan administration dealt with the natural disaster inadequately, and that there were violent demonstrations against her administration asking for prerogatives to assume rule. We can also see that the Transitional Council did as it's promised to return the power back to Derry when it assumed office. This concludes my submissions, and may it please the court.
Thank you. When counsel for the applicant is ready, we'll hear the applicant's rebuttal, please. Please proceed.
President Donoghue, honorable judges Nolte, Gomez, Robledo, applicant has 2 points for the rebuttal. First, respondent claimed that there is a customary exception to the functional immunity enshrined in draft Article 7 of the ILC on immunity of state officials. Although we recognize the undeniable trend to deny functional immunity in face of international crimes, it in no way constitutes the crystallized rule of customary international law. Bearing in mind the state practice elucidated in the recent report of Mr. Claudio Grossman, it does not meet the criteria of state practice being generally, sufficiently widespread, representative, and consistent, as required by draft conclusion of ILC 8 on identification of customary international law. Even Germany, a pioneer and a flagman in denying the functional immunity in face of international crimes, in its comments to ILC recognized what is the fatal for the sake of the respondent's argument, the absence of opinio juris. And given that this court should apply lex lata and not lex ferenda, the law of the future, under Article 38 of this court statute, Ms. Cross enjoys functional immunity. Secondly, respondent stated that some of the parties to UNCLOS questioned in 2021 uncertainty of legal application of sea-level rise in terms of UNCLOS and fixed baselines. However, the ILC in its 2023 report on sea level rise on the paragraph 152 found that existing state practice may support a particular interpretation of UNCLOS as providing for fixed baselines, which, Your Excellencies, is neither prohibited nor anyhow excluded from UNCLOS. In our case, more than 100 states endorse fixed baselines and others remain silent on this matter. Relying otherwise would lead to some states of the UN to gain more at the expense of other states, which maritime zones more allegedly, in face of repercussions by climate change. Therefore, ambrosious maritime areas are opposable to the respondent state. Thank you, and may it please the court.
Thank you, counsel. And now the respondent has an opportunity for Sir rebuttal, please. At the ICJ, the podium moves up and down, but here the flexibility is not quite so good. Please proceed.
Madam President, Your Excellencies, responding to the first point of rebuttal regarding whether a customary exception of functional immunity applies, we note that state practice is limited in this regard, but not for no good reason. In fact, the ILC in its 2016 report on the matter found that this is because of the rarity of the crime itself at paragraphs 188 and 189. And state practice, in view of the rarity of such occurrences, can still give rise to a customary rule of international law, as was recognized by Special Rapporteur Sir Michael Wood in his ILC draft articles or draft conclusions on the formation of customary international law. And where such crimes do occur, as has been acknowledged by a member of this court, Judge Tundaji, in his 2015 dissenting opinion to the Croatian genocide case, found enforced disappearance is rather limited. And where it has been limited in those regards, here there is indeed widespread acceptance of this custom in the Inter-American Courts of Human Rights. Moving then to address the second point of rebuttal concerning whether or not there is indeed state practice in support of a fixed baselines approach, we flip the applicant's case against itself when it considers the question of lex ferenda vis-a-vis the question of lex lata. Here, state practice and state submissions have been clear. For instance, the state of Colombia stated, and I quote, that therefore any conclusions reached regarding fixed baselines must be tentative. They will depend very much on the practice that states choose to adopt moving forward. With that, we submit that this court should find in favor of the respondent, and unless there is anything further, I conclude the case for the respondent, and may it please the court.
I thank the respondent. I thank both of the parties for their presentations, which have been very enlightening for the court, which now has the responsibility of retiring to deliberate.
I'll assume that relatively rare in-room round of applause was for one of the most active championship round benches we've seen in a long time. Wow. In particular, a personal observation, Judge Robledo came to drop bombs. All four of you. In a moment, the judges will be back with their decision. But while we wait, I'd like to thank a few people for their seminal role in making this such a wonderful week. First of all, the students and coaches. The level of competition this week and all year, the reports we've been getting out from all around the world your parents, your teammates, your roommates, everybody that has contributed to what we've seen every single day this week. Give yourselves an enormous round of applause. Our incredible judges from the national rounds and the friendly rounds here to the preliminary and advanced elimination rounds at the international rounds, you have stepped up your game, each and every one of you. You've put us all through our paces, including me. Thanks you very much to our judges. To my board of directors who make this possible by approving our budget, by approving the strategic plan for the organization, for giving me guidance, advice, admonitions, encouragement, so on and so forth. If I can ask the members of the board of directors and the members-elect to please rise. And then my core staff. In the judges' room, the incomparable Derek Moore, who has been recruiting and cajoling and encouraging and wrestling and wrangling our judges for months, not least of which this week. But Derek, it is a joy and a pleasure to work with you every year. Assisting Derek in the judges in what is increasingly becoming a unified judges and bailiffs room, we have Thais Neves, Amity Boyd, Jeffrey Brooks, Jenny Englander, and Megan Madamo. Please stand. I have my current and past student directors helping out this year at the information desk, hawking merchandise. I hope not hawking it. And all around just helping out everywhere. They're not in the room right now because they're monitoring the deliberation room, but please give a big round of applause for the sake of posterity to Larissa Rebello and Tarazi Mohammed Sheikh. Also not in the room, but she has carved out a role for herself from White and Case, the incredible Madeline George, who's upstairs. And of course, as I always do this year, an enormous thanks to my predecessor, my twice predecessor now, I guess, who coordinates well over 100 White and Case attorneys, staff, videographers, design team, support big and small, and also is an enormous personal support to me, to the entire executive office staff. And this is only a tiny part of her job and responsibilities at White and Case. Elizabeth Black. Overall, our partners at White and Case who are seated on this side, you have come out in force this year as judges, as remote coaches, including of our teams in Afghanistan. You have worked as national administrators, and not even including the material and non-material support that the firm provides. The world's greatest moot court competition and the world's greatest law firm. Thank you very much. Now, many of the teams who have earned their way here to Washington have done so by prevailing in national or regional rounds. These national rounds take incredible time, effort, and energy to organize and administer. And ILSA is deeply grateful to each and every one of our national and friendly administrators around the world that make those rounds possible. But each year I have the honor to recognize a few national administrators who have stood out for their ingenuity, intensity, and commitment to making the Jessup in their jurisdiction the very best for our students. Until last year, this award that I'm about to present was called the Stephen Schneebaum Award, named after our founding chair, Stephen Schneebaum. However, with the retirement of a truly great man and dear friend this year, the founding national administrator of the Chinese national rounds, Dr. Zhu Wenqi, we have, with the consent of the board, and in particular the former namesake, renamed this the Dr. Zhu Wenqi Award. We will, for the first time, and my colleague Christopher Bonnet traveled to China to present Dr. Zhu with a memento personally earlier this year at the Chinese National Rounds. I have the honor to present this award to three extraordinary women who, in the face of some pretty challenging events, took it on themselves to salvage their national rounds and really make them something special. Since none of them are in the audience, I'm going to ask the teams that are from there to please come down and accept the awards on their behalf. Last year, we had a fantastic team from the University of Carthage come, and their coach and advisor, Mariam McGraby, said to me, "Why don't we have more teams from Tunisia?" And I said, "Well, because we don't have any money, we don't have a national administrator, and there aren't any teams interested in competing other than yours." And she said, "Oh, is that all?" She found funding through our friends at the National Center for State Courts. She recruited 5 teams. They held a summer school. They put all of this together on very short notice. They invited judges from around the world to come and attend. And then in January of this year, all of their funding was cut. Mariam then took the whole thing online. Let's just reinvent the thing, and took it all online. We have 2 teams this year from Tunisia, one as a competing team and one as a exhibition team. And I'm told that they have plans to make it even bigger and better next year. And that's why the first Dr. Zhu Wenqi Award goes to our Tunisian national administrator. And I'd like to ask Team 333 to come down and collect the award on her behalf. Meanwhile, in Saudi Arabia, we had a team last year that came, and their coach said, "Why don't we have national rounds in Saudi Arabia?" And I said, "Because we don't have funding. We don't have any teams." And she said, "Oh, we'll do it." Unlike in Tunisia, when her university, Prince Sultan University, hosted, they didn't win. And we had a team that hadn't competed in some time from Dar al-Hikma University win the national rounds. Again, she was able to mobilize the expat lawyer and local lawyer community as coaches, as advisors, as judges, and really create in a very short time, in a period of months, a national rounds that, in my estimation, is built to last. And that's why I'd like to ask Team 353 from Dar al-Hikma to come down and accept for our Saudi National Administrator, Misbah Sabuhi.
Nice to meet you.
Meanwhile, in Nepal, Nepal has actually had a number of teams for many, many years. They have a long-established Friends of Jessup base. Most of the judges are themselves alumni of the Nepali Jessup program. But we had a new national administrator this year, and there were rivalries. There were hotly contested rounds. There were complaints and counter complaints, and remotely judged semifinal rounds, and all kinds of good things. And all of this in a situation where their financial and visa partners pulled out at the 11th hour. And our Nepali national administrator, Jessup was able through all of this to navigate and in fact to bring the Nepali national rounds out of the experience stronger. I believe that for the experience that she's gone through, it is a no-brainer that our final award this year goes to Jessup, and I'd like to ask Team 258, Nepal Law Campus, to please come down. I'd like to thank the only other permanent members of the ILSA Secretariat, the people who make my job possible. They make this competition possible. They are my poll star, my poll stars, I suppose. I'm not sure how that would work in navigation. You're the in-close experts. Roxana Nazari and Christopher Bonet. And as you can tell, if you've paid any attention at all this week, the Jessup Moot Court competition is run by the three of us, but it's driven by our volunteers, judges, administrators, and coaches. We have an army of now literally thousands of human beings around the world who truly love the Jessup, and the Jessup loves them. And so many years ago, ILSA established the Pamela M. Young Award to recognize exceptional volunteer service in any given year. This is my favorite award because it's the one award that's selected by me in my sole discretion, and nobody else gets to tell me anything. This one is long overdue in my mind. She has professionalized her functions in this organization. It's one of the most thankless supervisors of one of the most thankless roles, but her role is essential, and the roles of the bailiffs she supervises is essential. Ooh. We think we know who it is, say the judges. This year in particular, with questions about visas, with questions about who could travel, who could afford to travel, we were faced with incredible challenges in the bailiff's room, just recruiting and getting people to show up. Thijs was amazing. I mean, ordinarily we would say, let's invite more exhibition teams. Let's invite 50 or 60 exhibition teams. We'll just have them all bailiff. Thijs put together her usual army of Brazilian interlopers who judged with great professionalism, and at the same time mobilized judges into bailiffing, judges into timekeeping, and all the while keeping things moving at something that could easily become a choke point of this competition. And that's why, without question, this year's Pamela M. Young Award should and does go to Thijs Neves.
She is not here because she's running around. She's running around.
And under rules, if the Pamela M. Young Award winner is not here, I get to keep it. Thijs is off doing something important. All right, our next order of business. Hi, Thijs. I have something for you. Come on up. At this time, I'd like to invite Aditya Singh to the microphone. Aditya is a White and Case partner focused on international disputes and investigations. He's qualified to practice in India, New York, and England and Wales. Aditya worked in White and Case's New York and London offices before moving to his present home base, although it is merely a base in Singapore. Aditya competed in the Jessup on behalf of Nausar, and he's judged on the national level and here at the international rounds, including yesterday's semifinal round, for many years. He's also a member of the ILSA Board of Directors and therefore my boss and a member of the board's firm fundraising committee. And for another very special award, I'd like to invite up my friend Aditya Singh.
Thank you, Michael, and thank you for your leadership and all you do for the Jessup every year. Good afternoon, ladies and gentlemen. I'd like to begin by extending my warmest congratulations to all of this year's Jessup competitors. We have witnessed phenomenal advocacy this afternoon, but it's important to recognize every participant who traveled from all over the world for this year's Jessup. Each of you dedicated countless hours to the Jessup, and you should be very proud of what you've accomplished. Now, this year marks the 18th year of White and Case's global partnership with the Jessup. Throughout these years, we have continually looked for ways to celebrate and promote everything the Jessup stands for: the spirit of international cooperation, the highest standards of advocacy, and a commitment to the rule of law. 5 years ago, White and Case introduced an award to honor a Jessup alumnus who has made a profound impact on the legal profession and beyond. Jessup alumni have gone on to have great careers, have become influential lawyers, judges, academics, government officials, and politicians, each playing a critical role in shaping a just society. When selecting the recipient of this award, we look for a visionary leader who upholds the principles of international cooperation, the rule of law, and tireless dedication to the legal profession. This year, I am delighted to announce that the recipient of this award is His Excellency Judge Georg Nolte, member of the International Court of Justice. Judge Nolte participated in the Jessup in 1984 as a member of the team from the Free University of Berlin. His team won the German national rounds and placed third in the international rounds in Washington, D.C., also winning the Richard Baxter and the Ilona Evans Award for the best memorials. Today, Judge Nolte is widely recognized as one of the world's most renowned international legal scholars. But Judge Nolte's influence on international law began long before his appointment to the court. From 2007 to 2021, he was a member of the International Law Commission, serving as chairperson in 2017. During his tenure, he played a pivotal role in developing and codifying international law. From 2012 to 2018, Judge Nolte served as the Commission's Special Rapporteur on subsequent agreements and subsequent practice in relation to the interpretation of treaties, which we saw is a topic that is especially relevant to this year's Jessup. Now, in preparing these remarks, I spoke to my valued colleague at White and Case, Eckhard Helbeck. Eckhard and Judge Nolte were Jessup teammates in 1984. And Eckert recounted how Judge Nolte, even back then, had a pronounced sense of the importance of the international rule of law. This no doubt influenced his career choice, which was to teach international law, shaping young minds and contributing important research. As a renowned international law scholar, Judge Nolte has taught public international law for almost 4 decades at leading institutions, including as Dean of the Faculty of Law at Göttingen and as Professor of International Law at Humboldt University in Berlin. Ladies and gentlemen, it is inspiring to remember that Judge Nolte stood once where our Jessup competitors stand today. It is my honor and privilege to present the White & Case Distinguished Jessup Alumni Award to Judge Georg Nolte, and now we are pleased to hear from His Excellency. Thank you.
Dear Hatia Singh, dear participants of this year's Jessup, there are moments in life where much comes together. For me, coming back to the competition after a long professional lifespan that started with the Jessup competition, this is such a moment. I'm deeply grateful and humbled by being welcomed back to the competition in the overwhelming form of receiving the Jessup Alumni Award. I want to express my gratitude by putting my personal Jessup story in a larger context. The Jessup competition in 1984 was my first encounter with international law. I had not studied international law during law school. But somehow, after graduation, I became part of a group of 4 for whom writing memorials in the case of Industria versus Naturalia and the oral pleadings became the most enjoyable and most defining experience in their legal education. I'm very pleased to say that one of the members of my team, Eckhard Hellbeck, is present today, and some of you have been judged by him. Another member of our team, Jörg Polakevich, is now the legal advisor of the Council of Europe. I'm not saying this to show off my old friends or to suggest that you can count on a brilliant career. Yes, you can achieve everything, and you can reach any position in international law. But even if you are the best, and even if you try the hardest, this does not mean that you will be successful and that you will get what you want. Life is not like that. I would not have reached the positions that I have reached without having simply been fortunate in certain situations, or because I just happened to be at the right place or have the right nationality. So I do not try to persuade myself that it was all due to my particularly hard work or intelligence. There are many others who would have equally deserved to stand here where I am standing now. It is also for them for whom I accept this award. In 1984, I did not have any expectations as to how my professional life would develop. I did not even dare to have an ambition that went beyond the next 2 or 3 years. But I was curious about the world. In 1984 was perhaps the last year of the Cold War before a long phase of optimism started for international relations and progressive development for international law. When our team was in Washington in the final rounds, the parallel meeting of the American Society of International Law discussed the latest intervention by one of the 2 so-called superpowers in a developing country, that was the one by the United States in Grenada, today mostly forgotten. More importantly, a so-called missile crisis made many people feel acutely aware of the nuclear war. It was only a year later, in 1985, when the two superpowers miraculously started a long period during which international relations and international law flourished. The period which started in the mid-80s was a period for visionaries in international law. 5 years after my Jessup experience, I had the great privilege to learn from one of the great visionaries of international law at the time, from Professor Thomas Frank of New York University. He looked for fairness in international law, claimed a universal right to democratic governance, and found rights for the empowered self at the dawn of the Internet age. However, as dynamic the times after the 1984 Jessup competition have been, my own vision of international law was, and still is, one of sustainable development, so to say, with an emphasis on sustainable. There are rare moments when international law develops by a leap, unfortunately, mostly after armed conflicts. But normally, international law develops incrementally. It develops incident by incident, treaty by treaty, court decision by court decision, and not always in the same direction. Sometimes, when international law is challenged on a broader scale, we lawyers play a particularly important role in explaining, defending, and upholding the law with all the skills, courage, and energy that we have to keep the law resilient. It is this form of sustainable development and defense of international law which the Jessup competition prepares us for. Not just by teaching the language of the law and how to solve exemplary cases, but also by showing the way in which we can sustainably interact with each other and contribute to achieving legal certainty and the justice which law entails. The deeper purpose of the competition is to persuade you that the law, and particularly international law, is good and necessary for the world, and that international law needs people who carry it, who represent it. Now, there's clearly a danger involved here. The Jessup competition is playful, but let's be honest, it can also make you cynical. If you draw the conclusion that any proposition can be defended and that lawyers are hired guns, I think that such a conclusion is short-sighted, and it misunderstands the Jessup competition and the law. It is precisely because it is difficult for us humans to find the right solution that we must train our young people to be open-minded about the complexity of the problems and of the world, and to be able to see the world with the eyes of others. This may lead to them staring into the abyss. But this exercise is just the first step. The second and decisive step is the effort to integrate, after everything has been said, and to find the right solution, the relatively best solution with good conscience. It is with good reason that in law, we do not trust that any one individual can do this fairly enough. Therefore, we have collective institutions. Like courts, our best hope is that collective wisdom will emerge from such institution, wisdom which protects against arbitrary exercises of power, upholding rules and principles, particularly in difficult times. After my Jessup experience in 1984, I remained connected to the competition. Like so many former participants, I continued to be involved by coaching teams. During my academic career of 30 years or so, I've coached some 20 plus teams, most of which were better than my own team had been. And if that needed any proof, I can point to one of the many team members which I have coached, and which is here today, Janina Barkold, who is one of the co-authors of this year's Jessup problem, and who was my trusted advisor for 4 years at the International Court of Justice. These teams were highlights of my life as a teacher. So my Jessup experience in 1984 was the stepping stone for my life in international law. It has helped me to fill the roles which I had the privilege of playing in my professional life, including the one now at the court. My Jessup experience of 2025 today is a moment when much of this professional life comes together. And it is with my profound gratitude that I accept the Jessup Alumni Award. Thank you very much, and all the best to you all. Thank you.
I now have the honor to introduce the founding chair and current chair of the Board of Directors of the International Law Students Association, Stephen Schneebaum.
Thank you, Michael. My friends, what a wonderful occasion this is, and what a wonderful final round we have all just witnessed. Let me add the congratulations of the International Law Students Association Board of Directors to both of these exceptional groups of students from whom we've just heard. The National University of Kyiv-Mohyla Academy, representing Ambrosia, and Singapore Management University on behalf of Ravinia. Now, it is my great pleasure to take the podium to accomplish 3 tasks assigned by Jessup tradition to the chair of the ILSA board. The first of my assigned tasks is the one I most enjoy. I get to thank some people on behalf of the board. And to begin, I'm going to claim the right to speak on behalf of everyone here at the Hyatt and everyone watching this event on live stream around the world when I express our deepest thanks and our admiration for his success in pulling together the largest and best international rounds ever to ILSA's fabulous executive director, Michael Pyle. The energy, the creativity, and the sheer tenacity of Michael and his staff, you've all seen it throughout the year, that led up to this event have been extraordinary. And Michael, as we all know, as we just saw, is not someone quick to take the credit that he so well deserves, but he is also quite right to share recognition with his indefatigable team of Roxana and Christopher. And heartfelt thanks from the board also go again this year to the law firm of White & Case, the sponsor of these international rounds and the most loyal and dedicated team of professionals supporting this competition here and around the world. And I want everyone here to have the pleasure of meeting the new chair of the firm, who has joined us for this final round today, Heather McDevitt, a former Jessup competitor herself, incidentally. It is an honor to have you here. Will you please stand and accept the gratitude of the friends gratitude of friends of the Jessup from everywhere on the planet, and to all of the many white and case people who have been with us this week, we take this opportunity to thank each and every one of you as well. So that was my first task. My second role is a less happy one, but it is a necessary one. I invite everyone to join me now in paying tribute to the members of our community whom we have lost this year. Today, we remember 3 of our friends who have left us, and Ilsa and the Jessup mourn their passing. Mich Meissner was a friend of the Jessup for nearly 2 decades. Since joining us in 2005, Mich judged national rounds in China, Russia, Italy, and Canada, as well as across the United States, almost always accompanied by his wife, Marcia. He was always a welcome, friendly, and congenial mainstay in the international round judges' room. Mich was a partner at the Honigman law firm in Detroit for more than 40 years, specializing in real estate development and finance, but he loved the Jessup, and the Jessup loved him. Cynthia Lichtenstein, emeritus professor of law at Boston College Law School and a renowned scholar of international banking law, was a longtime member of the ILSA Board of Directors, having served several terms as our treasurer. She was also a Jessup judge, including at international semifinals, a coach, and U.S. regional administrator. In addition to her teaching and scholarship, Cynthia was a past president of the American branch of the International Law Association and a member of the board of editors of the American Journal of International Law. On her passing, the Boston College magazine memorial notice was headed, "Cynthia Lichtenstein made a difference." She certainly did make a difference to this organization and to her countless students, colleagues, and friends around the world. And once again, it is my sad duty to note the death of a young friend of the Jessup. Hamza Ilyas was a member of the 2025 Jessup team from the Millennium Universal College, Islamabad campus in Pakistan. He was in his final year of law school. At his birth, he was diagnosed with thalassemia major, a genetic disorder. The doctors said it was unlikely that he would survive beyond his teenage years, but Hamza was not discouraged. Despite frequent treatments and medical visits, he threw himself into mooting from the beginning of his law school career. Hamza was selected for his school's Jessup team last autumn, but he fell ill in December and passed away aged 26 after a short stay in hospital. He's remembered by his colleagues and teammates as kind and humble, a persevering soul, and an inspiring role model. Let me ask everyone please to rise and to join me in observing a moment of silence in memory of these 3 departed members of our Jessup family, Mich Meissner, Cynthia Lichtenstein, and Hamza Ilyas. Thank you. Now, those of you who were here last year will remember that we then mourned the loss of a great friend of the Jessup, Professor Ved Nanda of the University of Denver, who had died on January 1st, 2024. Today, we are inaugurating an award in his name for the best oralist in the international rounds. So I am especially glad and grateful to welcome Anjali Nanda, Ved's daughter, to our family. Anjali, please come up and receive a plaque in honor of your father. That is, if I can find it. And now, the moment that at least some of you have been waiting attentively for, I am going to announce the topics of next year's competition. Now, the veterans among you know that these sentences that I will now speak are the only clue you are going to get until September about the problem that will obsess students around the world until we meet again in April 2026. Here we go. The 4 questions presented by the Jessup problem for 2026 are, number 1, who may intervene in proceedings before the International Court of Justice? Number 2, what are the rights of indigenous peoples relating to rare earth minerals found in their lands? Number 3, what are the general principles of law recognized by civilized nations? We've all wondered that, haven't we? All of us. And number 4, when is a state immune from the domestic jurisdiction of another state when it has caused economic harm to citizens of that state? That's it. That's what you get. Now, finally, I'm going to abuse your patience. I'm going to abuse your patience for just a few more moments to share a thought that I am sure I was not the only one to have as I watched this superb World Championship Jessup round. What struck me most was the jarring disconnect between what we have seen here in this room and here this week and what we are witnessing every day in real time outside of this room. And I think it is important for someone to discuss this at an occasion like this. And if it's not on your mind, this issue, it should be. Because it is not an exaggeration to say that outside of this room, international law is facing existential threats, unprecedented ones, unconfronted, at least since the founding of the United Nations 8 decades ago. The growth of nationalism, exceptionalism, isolationism, protectionism is frightening. The willingness of states to commit flagrant and lethal violations of international law or to support others that do threatens the very survival of the global legal regime. And that the leaders of nations long responsible for the development and promotion of international law are now among those most willing to dispense with that legacy places the future, even the short-term future, of the planet in jeopardy. That is what is happening outside of this room. And yet, inside of this room, the spirit of international law does not just live, it thrives, and we celebrate it. Inside of this room, we are dedicated to the principle that disputes between nations can and must be resolved peacefully in accordance with the rule of law as developed within the world community. Inside of this room, we have just seen the best of a new generation of students and advocates committed to stopping the assault on that principle, whose sanctity we have taken for granted for far too long. So today, my friends, as we leave here, as the 2025 Philip C. Jessup International Law Moot Court Competition fades into history, we as students and teachers and practitioners of international law are faced with a challenge. We must redouble our efforts to ensure that our leaders act in the same spirit and with the same resolve that we have seen here in Washington, culminating in this room this week. We must not tolerate the dismantling of the rule of law in our own countries and around the planet. We must, in other words, take what we have seen inside this room and defend it, expand it, and live it outside of these walls. International law is not just a subject of academic study. It is not just a field of professional practice. We, the citizens of the planet, have a choice: an international community governed by law or a world descending into chaos. My plea to you and my challenge to you is this: as you leave here and as you return home, remember what you saw here. Remember the people from other countries and other cultures whom you met here, who are just as dedicated to international law as you are, and resolve to promote that dedication, the value of the Jessup competition and the Jessup family, wherever you go now, throughout your careers, and throughout your lives. That, when all is said and done, is what your commitment to this international law moot court exercise is all about. It is to take what is inside of this room and to plant it firmly outside of this room. So now I am informed that the judges are ready to tell us what we all want to know and to announce which team will have its name engraved on the Jessup Cup over there as the world champion for 2025. So welcome to those of you who are new to the Jessup family. Welcome back to those of you who are already in the club. I look forward to seeing all of you next year and the year after that. Thank you.
Please be seated. The judges are, of course, aware that the parties, all of you in the room and others who are watching remotely, want to hear the results from us. But before we get to that, we're going to each offer a few general remarks. And for that, I will give the floor first to the two other judges. Please go ahead.
Thank you very much, President. I want, first of all, to congratulate each and every one of you for having done such an impressive work. I am really, really impressed by your commitment, your engagement, the quality of your work, the skills that you showed and demonstrated to us, and the fact that we all know that you've been working for at least a year continuously on this case. It involves a great number of things, and I think it's very inspiring to see you. It's very inspiring, particularly in the present international circumstances. So I feel really privileged to having been part of this competition. I very much hope that there will be many more to come in the years to come. And I would say also that if you believe that in reality the work at the ACJ is harder, I think you would be mistaken. What you have done is much more harder than what we do on a daily basis for a number of reasons. One of them being the fact that we have time to deliberate, have time to assess the evidence, we have time to ponder and every single argument. And you've been through these 14 times, but I I feel confident that at each time, in the various stages of this competition, it has been different. So it's not just a repetition of the arguments. So you have clearly shown a great ability, great commitment, and of course, a passion, true passion for international law. And I wish you that you maintain that passion, and that this competition will, I hope, define your future endeavors and career. Thank you.
Thank you very much. I agree with everything Judge Gomez Robledo has said, and I know that I have already taken some of your time, so I will focus on one point. One of the frustrations of the Jessup is that the problem is usually so complex, so big, and the time for the oral pleadings is so limited that as a judge, you don't know, you want to ask many questions, but you know that you take time away from those who plead, and we don't exhaust the case. And that problem cannot really be solved. In my Jessup experience, it more often than not happens that teams try to solve the problem by machine gun technique. They are trying to speak very fast and try to get over as many points as possible, and also sort of trying to ignore questions in order to finish. What has impressed me in this final was I shouldn't say relaxedness, but the coolness, la force tranquille, as a candidate for French presidency has once said, that both teams, both pleaders of the teams have shown to us, speaking slowly, not appearing to be in haste, thinking about what they are saying, not reading, responding to our questions. And I enjoyed that. Thank you very much.
So I'll just add a few remarks of my own to those of my colleagues with which I agree. The first is, I'm sure that all of you here and watching remotely have, as part of your preparation, looked at actual arguments in the International Court of Justice, and you've probably already figured out that the task that you face in the Jessup is actually much more difficult than the task that is normally faced before the International Court of Justice, because the court rarely asks questions, and when it does, usually gives a party time to respond rather than to respond on the fly. So every one of you deserves great credit for having the facility to respond promptly to questions. And the second point I wanted to make is that you, I think, all know by now that the authors of the problem are people who have had extensive experience at the International Court of Justice, as a result of which they've written for you a problem that was very dense and very difficult, meaning that many of the issues were amenable to more than one good answer. And so that is essentially, from a standpoint of the Jessup process, a great problem, but it also heightens the effort that all of you have to undergo in order to perform well here. So I give all of you enormous credit for having proceeded so far, those of you here who are in the international rounds, and those of you who participated in earlier rounds as well. And I would like to echo the point that was made by Judge Robledo Gomez about the plea from us that you continue your interest in international law. For me, judging the Jessup being here in front of this size of a group is incredibly inspiring. So we hear, oh, you're pleased to appear before us, but we want to make sure you know we are honored to be in front of all of you. So now I have two final tasks to indicate the person who we've chosen as the best oralist, and then to indicate the team that we find as the winner of this final round. So as the best oralist, we find the best oralist to be Ms. Erica Wee. And as the team that we find to win the championship round, we find for the respondent. I don't know what we're supposed to do. Congratulations.
I thank both teams. I thank our incredible championship round bench. And I hereby declare the championship round and the 2025 international rounds closed. Thank you all very much.